Hi, good afternoon, everybody. I'm Brian Kuhn, the NEMA President and Director of the Florida Division of Emergency Management. I'm going to be the moderator today for our webinar entitled Implementing FEMA's FNSS Guidance Using Community-Based and Private Sector Resources. So this is our first NEMA webinar. We're very excited to have you here today. We've got two fantastic presenters today. Very excited to have them with us, Linda Mastandrea and Kyle McPhee. Ms. Mastandrea is an attorney with significant litigation, consultation, and advisory experience in the Americans with Disabilities Act, the Rehabilitation Act, Individuals with Disabilities Education Act, and state and local disabilities laws. She is a subject matter expert on FNSS training and disability law issues, and she has developed and presented numerous trainings for audiences worldwide, including emergency managers, on these topics, as well as teaching disability law as an adjunct professor at Chicago-Kent College of Law. In her previous position as the National Director for Emergency and Disaster Management with Inclusion Solutions, Ms. Mastandrea developed and marketed functional needs support services and accessibility product solutions for the shelter and evacuation of people with disabilities and functional limitation. Mr. McPhee, Kyle, is an experienced emergency management professional with a history of working in various organizations focusing on homeland security, business continuity, public health, and emergency management. He has experienced working with and providing customized emergency management solutions specific to mass care and sheltering operations. He currently manages and oversees the emergency preparedness programs for Hagerty Consulting. So with that, I'll turn it over to Linda and Kyle, and you will see and hear me again at the end of the webinar as we start working through the questions. So Linda, Kyle, the floor is yours.
Thank you, Brian. Good afternoon, everyone. Over the next 45 minutes or so, Linda and I will work through an agenda. We will start by discussing which laws and regulations establish our standards for compliance, functional needs support services being the driving factor for that. Then we'll get into what compliance looks like and answering the question, how do case studies affect compliance? And finally, begin to discuss how to engage the private sector and meeting the needs as described above. And we really will focus on a three-step process, knowing your community, knowing your resources, and knowing your programs. So with that, let me pause here and transition over to Linda to get us started with which laws and regulations establish standards for compliance.
Let's begin by talking about why the Americans with Disabilities Act and disability laws and regulations exist. I'm going to read the quote on the slide for you here. When police with megaphones rolled through Carol Lazorazak's New York City neighborhood in the hours before Hurricane Sandy thrust shore, she did not hear their announcement about evacuation help. She eventually joined thousands of other dazed victims at a local shelter. But for Ms. Lazorazak, who has been deaf since birth, walking through the bustling relief center was like being in a movie on silent. There were no signs providing information for the deaf or directing people to translation services. She left feeling more isolated than ever, end quote. And this is from the National Council on Disability. This quote is a powerful reminder of why laws like the Americans with Disabilities Act are needed to ensure that individuals with disabilities are included in emergency and disaster preparedness from the beginning to the end. And it reinforces the need for the FNSS guidance that we're talking about today. Functional and Access Needs Overview. The Federal Emergency Management Agency, FEMA, modified definition of functional and access needs, or AFN. Individuals requiring functional needs support may have physical, sensory, mental health, cognitive, and intellectual needs that affect their ability to function independently, especially in the aftermath of disasters. And functional needs support services, or FNSS, are defined as services that enable individuals to maintain their usual level of independence in a general population shelter. These definitions put into context for us decades of legislation regarding people with disabilities. These aren't creating new law or new regulation, but they're expanding on what already exists. And the FNSS guidance, Functional Needs Support Services, FNSS guidance, was created specifically to help emergency managers better plan for and serve the people with disabilities in their jurisdictions. And the overarching foundation for the FNSS guidance is based on these principles. Number one, equal opportunity. making sure that people with disabilities have the same opportunities to participate in all the programs and services offered by the emergency manager. Second principle, integration. This means people with disabilities are served side by side with non-disabled people, not in separate shelters or separate facilities or locations. The third principle, individualized assessment. This means there is not a one-size-fits-all approach to working with people with disabilities. For example, just because one deaf person uses sign language doesn't mean that all deaf people you come across will. The fourth principle is self-determination. This means that people with disabilities are in the best position to tell emergency managers how to help them. The fifth is reasonable modifications, and we're going to hear a little bit more about this later, so I'm not going to go into great detail about that, but this can include changes to policies and procedures to better accommodate people with disabilities. Number 6, inclusion. This means including, just like what it sounds like, including people with disabilities and the organizations they work with in planning, outreach, education, training, all the activities that encompass emergency management. And for example, having people with disabilities at the planning table and including them in disaster drills and exercises so that both first responders and the people with disabilities themselves get real-world experience. Architectural accessibility is a key component, ensuring that all emergency management activities, from training to sheltering and post-disaster housing, are all in physically accessible locations. Auxiliary aids and services. These are things that ensure effective communication, like sign language, like captioning, like Braille, large print, and video relay services. Another important principle to keep in mind is that you can't impose surcharges on people with disabilities. For example, you can't charge for the costs of accommodating an individual in a shelter. And finally, emergency managers can't contract with providers who violate the law either, such as contracting with a shelter provider who operates an inaccessible facility. So these are the principles that really frame the whole bedrock of the FNSS guidance that we're going to be talking about today. So now we're going to get into a little bit more meat about the laws, regulations, and guidance that really underpin what FNSS is all about. FNSS, in federal, state, local, and tribal laws, regulations, and guidance, exists specifically to prohibit discrimination against individuals with disabilities in programs that receive governmental funding. The following lists FNSS relevant laws, regulations, and guidance. The Rehabilitation Act of 1973, the Americans with Disabilities Act of 1990, Titles 2 and 3, the ADA Chapter 7 Toolkit, FEMA's guidance on planning for the integration of functional needs support services in general population shelters from 2010, or the FNSS guidance, local and state laws and regulations, and of course the Fair Housing Act. So let's talk about each of these in turn. The Rehabilitation Act is really kind of where it all began. This was enacted in 1973, and it provided that federal government entities and federally funded programs couldn't discriminate against people with disabilities. Next came the Americans with Disabilities Act, or ADA. Now this took the protections of the Rehabilitation Act one step further and included private entities, employers, and state and local governments. So it took it from beyond just federal government protection to basically any entity. And the two particular titles that emergency managers need to be concerned with are Titles 2 and 3. Title 2 of the ADA deals with state and local governments. And this, as you might imagine, comes into play with our state and local emergency management programs, ensuring that they are accessible to people with disabilities. And Title 3, which deals with what we call public accommodations, can apply to things like training exercises, meetings, or shelters that aren't housed in government buildings, for example. The Fair Housing Act deals with housing discrimination across all kinds of categories, including disability, and is extremely relevant to the issue of post-disaster housing. Jumping back up on our list here, the ADA Chapter 7 Toolkit was issued by the Department of Justice, and this is part of a larger document that has chapters dealing with all different types of state and local government issues. Chapter 7 in particular deals with helping state and local governments make emergency management accessible to people with disabilities. It includes things like a comprehensive checklist for your programs, as well as a checklist for your shelters to evaluate their accessibility, and it even has suggestions on how to make them compliant. So it's a very useful toolkit. Next, the FNSS guidance published by FEMA in 2010. This really works hand in hand with the laws, regulations, guidance, with the ADA toolkit to ensure people with disabilities are appropriately planned for and accommodated throughout the emergency management landscape. And finally, many local and state laws and regulations provide guidance as well on non-discrimination against people with disabilities, but they aren't a topic of discussion for today, so we're not going to go into great detail on that area. So what does compliance look like? So here we're going to talk about compliance versus this notion of accommodation that you heard me mention a few minutes ago. Compliance requires adopting disability laws, regulations, and guidance into programs. Case law provides examples for the need to incorporate FNSS into all phases of emergency management to ensure compliance. Disability accommodations, on the other hand, are things like reasonable adjustments to programs to ensure compliance. And here we have a table that sort of lays out some distinctions. Compliance includes things like reasonable accommodations, access to durable medical equipment like wheelchairs, walkers, things like that, access to consumable medical supplies like diabetes supplies, access to personal assistance services like people who help individuals with disabilities do their activities of daily living, like eating, bathing, dressing, things like that. These can all fall under compliance. Reasonable accommodations, on the other hand, include things like modifying plans, policies, and procedures. For example, modifying a policy that states no pets are allowed to allow for a service animal to be admitted into a shelter or another facility. Stating the process and procedure in jurisdictional plans for meeting unmet needs. This simply means having plans in place to meet the needs of people with disabilities in your jurisdiction in an emergency, having a plan in place in advance. And finally, utilizing all jurisdictional and regional resources to meet the needs of residents, including all the things that we've talked about, from communications, transportation, accessible sheltering. So what this means really, this notion of compliance versus accommodation, is that accommodation is part of compliance. They go hand in hand, and you can see they sort of, morph and meld into each other. And accommodation more broadly can be thought of as simply ensuring that people with and without disabilities have the tools they need to access and benefit from the emergency management program. The goal is really success for both parties. The person with disabilities is evacuated, sheltered, and returned home safely. The emergency manager successfully evacuates, shelters, and returns that individual home. Having a process and procedure in place is critical, so emergency managers have a framework on how to ensure that people with disabilities are planned and prepared for. Thinking about this sort of at the highest level, compliance is kind of like ensuring your facilities are accessible. But accommodation, on the other hand, is having that checklist or that process in place so that when someone comes to a shelter, you can assess them and figure out what they need and give them the tools and services they need to successfully live and stay in that shelter. So now let's turn it over to Kyle for a couple of minutes, who's going to talk about compliance in all phases of emergency management: preparedness, response, and recovery. Kyle, over to you.
Thank you, Linda. We feel it is essential to recognize that to answer what does compliance look like, activity must be considered in all phases of emergency management. At the left-hand side of your screen, you are seeing a simplified version of the emergency management lifecycle. Compliance should be incorporated into all phases of emergency management, beginning with the planning and preparedness phase. The majority of actions by local jurisdictions should occur during this phase to ensure that individuals with access and functional needs maintain their usual level of independence while receiving services. The following lists what compliance looks like during planning and preparedness phase, and I should just note that this isn't an exhaustive or all-inclusive list. These are just some examples that we feel are most critical to successful programming and planning. So the first here is inclusion in all plans, policies, and procedures. And what we're talking about here is the inclusion of individuals with access and functional needs or other disabilities in your regular emergency management programs. Whatever your priorities are, think about opportunities to include these individuals in your programs. It's really building off the mantra, nothing about us without us. The second bullet here is having trained staff, paid and unpaid, and other stakeholders or first responders. What we're talking about here is that training leads to implementation, and the biggest barrier we see consistently with implementing compliant programs is education, understanding of what the law says, understanding of what compliance truly means. And so opportunities like this today are a good step in that direction. Having up-to-date private sector, public sector mutual aid contract for accessible facilities, transportation, personnel, equipment, and other necessary resources. What we're really advocating here is an honest assessment of the current condition of your programs, identifying needs and gaps, and being able to identify community-based resources to meet those needs. I'm going to talk about an example later in the presentation where we've been able to assist a jurisdiction with this. The final bullet here, assessment of potential sites and remediation plan for noncompliance. An example of this would be assessing a mass care site or a shelter for compliance with the ADA Chapter 7 toolkit. And I'll provide a further example of this later in the discussion. Further compliance and response. During the response phase, jurisdictions should utilize all resources at their disposal to ensure individuals with access and functional needs maintain their usual level of independence while receiving services. The following lists what compliance looks like during the response phase, and again, isn't necessarily an all-inclusive list. The first and most often identified barrier is communication. So aids and services to ensure effective communication are critical. One low or no cost solution is having pictograms or talking boards available to your staff. You can also access the private sector for translation services by a standby contract vehicle or to do text messaging to meet certain populations. The second here is taking a critical look at public sector accessible facilities, transportation, personnel, equipment, and other necessary resources. And where you identify gaps, seek private sector contractors for those same facilities, personnel, transportation equipment, and other necessary resources that aren't readily available in your public sector cadre. You might look at local centers for independent living for some of this, or you might look at standby contracts with certain vendors. As an example, for town hall meetings, having interpreter services available or other accessible communication methods to make sure that the entire community is receiving the critical information. And then finally, as a general principle that applies to all activities in response, inclusion in activities and programs. So we've seen some creative solutions to this working with various jurisdictions across the country. Some of those would be an advisory board that's attached to your policy team and your EOC, or having some sort of deployable assessment team that can go out to a mass care site and help assist in identifying individual needs and ensuring that those are met in a timely manner. During the recovery phase, jurisdictions should continue to utilize all resources at their disposal to ensure that individuals with access and functional needs will maintain their usual level of independence while receiving post-disaster services, and to integrate post-disaster lessons learned into planning and preparedness phase. The following list what compliance looks like during the recovery phase. Again, not an all-inclusive list, but think about things like planning for accessible post-disaster housing and programs. Taking a critical look at after-action reports and improvement plans of exercises and field operations to identify opportunities to be more inclusive of key demographics in your community. Continue to use aids and services to ensure effective communication. Continue to use accessible public sector facilities, transportation, personnel, equipment, and other necessary resources. and contract to the private sector for those same items when they're not readily available. What we're saying here is just think through contingencies and recognize that it's not a one-size-fits-all solution, and need to really take a critical look at the community's demographic and apply that to post-disaster operations as well. One thing expanding upon this is begin to look at more long-term recovery is building and rebuilding in a way that's more accessible and that improves the quality of life for the community. And looking at the Joplin rebuilding effort is a great example of that. So Linda, let me turn it back over to you to talk about how do case studies affect compliance.
Terrific. Thanks, Kyle. All right, so we're going to talk about two different cases here that are really excellent illustrations of things that can go awry in the emergency management universe. And as a lawyer, you know, it is honestly not my favorite thing to do to litigate against people. It is my favorite thing to do to get good results for all people concerned. And that's why I bring the case law examples to your attention today, because these are just good instructional tools that you can take and learn from so that you can better prepare yourself knowing what went wrong in the past so that you can do better in the future. And these are two different yet interesting cases. The first one is the California Foundation for Independent Living Centers and Californians for Disability Rights. They filed suit against the City of Oakland under the Americans with Disabilities Act, the Rehab Act, and the California state law. They alleged discrimination against the over 84,000 residents with disabilities in the city because the city failed to sufficiently plan to meet the needs of those people with disabilities during an emergency or disaster. And for example, the things that they alleged in their case were that potential shelter facilities were physically inaccessible, mass care shelter and policies and procedures and plans were either inadequate or totally non-existent. The City of Oakland didn't have an inventory of shelters that were accessible, or even an inventory of what shelter supplies they had that would be useful to individuals with disabilities. They didn't have agreements in place with community-based organizations or pharmacies or providers of medical supplies and equipment. They had no arrangement for the transportation of people with disabilities. And they had no plan to provide accessible information and communication to people who were deaf or blind or cognitively impaired, or even for those who didn't speak English. And the plaintiffs in this case also said that they were really concerned that the City of Oakland's plan at the time of the suit was 20 years old, even though the city had up until that point 8 presidentially declared disasters, including fires, floods, earthquakes, and landslides. So what had happened is the city had reviewed its plan in the year 2005 and found that they did need to improve their emergency planning to more fully address the needs of people with disabilities. So they were aware of the need. And they put out a request for proposals for someone to do a plan. A year later, an engineering design firm they hired submitted a proposal for a mass care and shelter plan incorporating the needs of people with disabilities in the plan. And yet a year after that, still no contract was in place to develop or implement that recommended plan. And it was at that point that these individuals and organizations filed suit. And ultimately, this case was settled. The parties agreed to develop and implement an annex to the city's mass care and shelter plan to address the needs of those 84,000 or so people with disabilities in the town. And this functional needs annex that was developed included plans to remove not only the architectural barriers that existed, but also to address the needs of people with disabilities across 5 different categories: communication, medical needs, the maintenance of their independence, supervision, and transportation. And the case settlement also included a court-appointed monitor, and a pretty substantial payment of attorney's fees. And so what did the non-compliance look like here? You had potential sites that were physically inaccessible, inadequate or non-existent policies and procedures, no contracts existed for transportation, equipment, or personnel, And you're talking about a population of somewhere in the vicinity of 84,000 residents who had access and functional needs. So what are some of the solutions? What are some private sector solutions that can really ameliorate these issues and help avoid this in the future? Number one, potential sites can be retrofitted by local home improvement companies and contractors to become physically accessible. Number two, of course, plans, policies, and procedures. These can incorporate advocacy group recommendations and, of course, be updated regularly to reference new laws, new regulations, new guidance. For example, if you've got plans and policies that predate the FNSS guidance from 2010, you need to update those to incorporate that guidance. Finally, contracts can be established with local businesses and organizations to provide functional needs support services for everything from refrigeration for medications and supplies for service animals and everything in between. So there's lots of different solutions and lots of different ways to avoid some of the situations that California found themselves in this case. And often what we fail to recognize is that the resources that we need are right at our fingertips, right in our communities, and we just have to involve the people who have the answers that we're seeking. We don't need to know it all ourselves. We just need to know the people who have those answers. And the second case I'd like to share with you today is Brow versus FEMA, or the Federal Emergency Management Agency. So this was a post-Katrina and Rita case filed by evacuees in 2006. And this case solely dealt with people with disabilities who needed accessible trailers for post-disaster housing, but they got either an inaccessible trailer or no trailer at all. And though there were actually about 25% or so of Katrina evacuees who were identified as people with disabilities, only about 1 to 2% were actually provided with accessible trailers. So a class action suit was filed, and as a result of this suit, which also settled, they agreed that 5% of all trailers in the future would be accessible. FEMA created a toll-free number for people with disabilities to request accessible trailers or modifications to a non-accessible trailer. And then FEMA had a time frame within which they had to either meet the need to modify or provide an accessible trailer. They instituted a complaint review mechanism, and they created a communications plan to reach evacuees who might actually be eligible for the accessible FEMA trailers, but didn't know that they were. And of course, plaintiffs' attorneys also recovered some pretty substantial fees here. So what did the noncompliance look like in this case? Again, we've got a case alleging a violation of Section 504 of the Rehabilitation Act and the Stafford Act and the Fair Housing Act for inaccessible post-disaster housing. These trailers didn't have accessible entrances, they didn't have accessible bathrooms, they didn't have accessible kitchens, so people using wheelchairs and who had limited mobility really had no effective use of this housing. The case, as I mentioned, was settled. FEMA ultimately provided 1,400 new accessible trailers and modified more than 250 of them. So again, what can we learn from this case to do differently going forward so that there isn't another Brow versus FEMA or Brow versus whomever? Private sector solutions, what can we do? Number one, about new post-disaster interim housing. This can be designed, again, consulting with advocacy groups or consulting companies who work in this space and making sure that the designs are accessible from the ground up, then you don't have to worry about retrofitting. On the other hand, if there is older post-disaster interim housing, perhaps it can be retrofitted by home improvement companies and contractors to become physically accessible. Third, long-term recovery plans, policies, and procedures can and should be revised with advocacy group or consulting companies' recommendations, again, updating them to include reference to new laws, regulations, and guidance so that everybody makes sure that you're on the latest and most current version of the laws and regulations. And finally, contracts can be made to ensure access to social and civic activities and programs, therapists, medical providers, etc. When you think about it, safe and accessible housing is a crucial need for people with disabilities, not only before a disaster, but during and after. And returning people with disabilities to life in the community with access to all the services and supports they had prior to the disaster is vitally important and really another key takeaway of this case. So next, I'm going to bring Kyle back for a minute to give us an overview on engaging the private sector, and then I'll come back with some more specific examples. So Kyle, back to you.
Great, thanks. In working with various jurisdictions around the country, we've found that keeping it simple is what's key to success. So there's lots of things that we've already discussed and many more that we haven't that could overcomplicate this process. Our approach has boiled engagement down to 3 primary steps. Step 1 is about knowing your community. This includes assessing and understanding the culture, demographics, and trends, as well as having context of past conversations that have occurred with the community on this topic. Moving on to step 2, it's about knowing your staff, equipment, and infrastructure. This includes working through potentially a local chamber of commerce to identify private sector partners active in the space, assessing the status of infrastructure, and engaging members of the disability community in discussions about what are the essential services they use day to day. Finally, it's about knowing your programs. Don't reinvent the wheel is the bottom line here. What's going on currently in the community? How are activities already being undertaken for polling places or other more routine events? How could they be rolled into your emergency planning efforts? And so we have some specific examples on each of these steps that Linda will provide some additional insight on.
Private sector engagement, our first point here, know your community. First, you want to develop an understanding of individual access and functional needs in your community. And we have the example here of forming relationships with local advocacy groups. So there are likely many groups in any community across our nation serving people with disabilities and other access and functional needs, like serving people who are blind, who are deaf, who are spinal cord injured, who have diabetes, who have Alzheimer's, and the list goes on. And like I mentioned a few minutes ago, these resources are right there for you. They have key information on who they serve, what those individuals need, and what the agency themselves can do to assist emergency managers in their mission. And by getting acquainted with these organizations, you'll be better able to assess your population and plan to meet their needs. Next, determine the needs of the most vulnerable populations. An example, consult with independent living centers. So Centers for Independent Living, which again we can find in virtually any community across the country, are an excellent resource for assisting emergency managers with assessing a community's disability population and getting a handle on what their needs might be in an emergency or disaster, as are assisted living facilities, nursing homes, and group homes. Plus, these organizations are really uniquely able to educate emergency managers on things like the appropriate language to use when dealing with disability, appropriate methods of communication, how to provide assistance to wheelchair users or people who are blind or deaf or have other disabilities. Again, that resource is right there at your disposal in your community. Next, ensure that communication can occur with the access and functional needs population. For example, partner with private sector businesses that provide alerts in a variety of forms and in different languages and various formats. And so why is this important? Well, people who are deaf may need sign language interpreters, but they may need video relay instead. People who are blind may read Braille, but they may not. They might need large print or audio. Effective communication takes many forms. And remember what I said earlier, this isn't a one-size-fits-all thing. It's really about individual assessment and knowing the needs of your community and what they need. And for me, the ultimate takeaway here is that communication with your community, with this population, is key. When you talk to the people with disabilities in your community and the agencies that serve them, when you get to know them, when you really listen to their needs and concerns, guess what? They're less likely to file complaints against you. They're less likely to litigate against you. And in fact, you'll be able to work better together to ensure that your whole community is safe and well served, no matter what emergency or disaster comes along, because you're communicating with each other and working together. Let's talk about private sector engagement, knowing your staff, equipment, and infrastructure. First off, utilizing local businesses to contract for supplies. For example, working with your local DME or durable medical equipment and CMS or consumable medical supply businesses for access to resources like electric or power wheelchairs, oxygen tanks, diabetes supplies, etc. Utilize local businesses to contract for personnel. For example, contracting with VRS, video relay services, and with local interpreters to communicate on different platforms and in different languages. So VRS, or video relay, this is one of the most popular methods for deaf people to communicate with today. Many state offices, I find, maintain TTYs, or teletypewriters for the deaf, but this is very much an outmoded form of communication that most deaf people no longer rely on. So video relay is really the primary mode that people are going to want to use, in addition to things like texting. Utilizing local businesses to ensure site compliance. For example, partnering with local businesses to provide portable ramps, lifts, and other temporary access equipment, or looking at local contractors to retrofit for more permanent access solutions. So again, I'm going to sound like I'm repeating myself, but the theme here is really knowing and understanding the resources available to you in your own community. There's far more than you even think you have. And like Kyle said, emergency managers don't have to reinvent the wheel or have all the answers. The CILs, Centers for Independent Living, the other disability organizations are willing and able partners that can really step up and help you do your job better and more effectively. So communicating with them and establishing good relationships with them will go a long way towards solving any issues you may have today or that may crop up in the future. So finally, private sector engagement, knowing your programs. First off, review your activities and programs off-site. For example, teaming up with local paratransit providers if activities and programs occur off-site. And this is important because accessible transportation is a key component of any emergency manager's plan. Your community might have paratransit available, it might have accessible mainline buses or vans that are owned or run by senior centers or recreation centers that you can use. Next, conducting training to ensure an understanding of compliance. For example, partnering with consulting companies or local advocates to train staff on plans, processes, and procedures. Again, the organizations that I've mentioned again and again here, CILs and others, are a great resource for this kind of training. And finally, conduct compliance assessments. For example, consider receiving support from consulting companies to conduct program strategy compliance assessments, site assessments, and recommend solutions for noncompliance. There's a lot of qualified providers out there in both the disability advocacy and emergency management consulting arenas who can help you develop some excellent plans and programs. So we've got to ensure that not only are our shelters compliant, but our off-site programs and facilities are. Ongoing training ensures that we have the latest knowledge of the law and disability issues to best help our residents with disabilities. Making sure our DRCs are physically accessible, that staff are trained, that materials and communications are accessible, that the programs and services provided there are offered in an accessible and appropriate way is really important. And as I've mentioned again and again, there's lots of people in your community who can help you as emergency managers assess your facilities and programs and ameliorate these deficiencies. And finally, don't forget, you've got great free resources available to you as well, like the ADA Chapter 7 Toolkit. So now, I'd like to turn it back to Kyle for a real-life example of assessing for compliance. Back to you, Kyle.
Thank you, Linda. As we close today's discussion, we wanted to provide a real-world example of where this process has been implemented. Again, a three-part process was implemented. First was an overall program assessment. This was a strategy assessment which first evaluated programmatic information on activities and programs in Fort Worth. The survey focused on policies, procedures, and agreements in place to support inclusive operations. So we recommend you really start with at the strategic level, looking high level across multiple programs, multiple departments, and evaluating, are things currently in line? Do they reflect current guidance? Moving on to step 2, then we began to look at individual sites or infrastructure. Each site assessment included measurements of space, slopes, pressure for compliance. This survey determined accessibility for things like parking lots, entrances, walkways, drinking fountains, among other things. And then finally, step 3 was the output, recommendations for improvement. Individual deficiencies were noted for each facility, and final document provided suggested recommendation improvements to ensure compliance. This was both based on the site assessments and the overall programmatic assessments or the strategic assessment of the jurisdiction. So as a result, our recommendations included a variety of different attributes, and we've just selected a few of them here just to give you a sense of the type of analysis you might want to do in your jurisdiction. So first, our general accommodation recommendations. The subjects included transportation, communication, and service animals. On transportation, our recommendation was to include accessible transportation for daily activities and programs in the plan. Activities may include prescription medication pickup, doctor visits, laundry, or shopping. So something that's interesting here is the capability existed within the jurisdiction, but it was about including that element into the plan and having a documented process in place. Second, as far as communication goes, ensuring that staff are trained in providing assistance to clients that are unable to complete forms, policies are formalized in writing. So 2 things there. 1 is to focus on training, and that's an ongoing effort. And 2, to ensure that those communication practices are formalized in your plans, policies, and procedures. As far as service animals are concerned, ensure that written procedures exist, that clients and service animals are not separated. Include food, water, receptacles for disposing waste are available for service animals. So these are general recommendations that might apply to a number of jurisdictions and focus on just a few key attributes that you'll also see reflected as you begin to look at things like the ADA Chapter 7 Toolkit or FEMA's FNSS guidance. More specific accommodation recommendations might include support agreements, the specifics of a facility's accessible or non-accessible parking, and to get very tactical, something as simple as sink hardware. The sink as in how you wash your hands and if that's accessible or not. So as far as support agreements are concerned, ensuring that written agreements have documented requirements for compliance, so ensuring that those agreements that you're in, as Linda mentioned several times previously, that they do reflect current laws, regulations, standards. And then following through to ensure that those entities actually comply with ADA. Documents may include costs for supplies and assigning responsibility to those costs, and everyone that's worked through a mutual aid type agreement before is familiar with that. Non-accessible parking. A general standard is we kind of drill down here. If no or fewer than the required designated parking exists, a parking lot can be permanently restriped with 2 common spaces combined for an accessible space, or traffic cones can be used to block off an adjacent space for an access aisle. Again, the difference between a more permanent retrofit or a temporary solution to meet an immediate need. And finally, sink hardware, replacing knobs with lever hardware or touchless model, the touchless models being the preferred action. So you can see how there's both strategic elements to consider and then very tactical elements to consider at individual sites. One thing I would reference is that if you have questions about the specific requirements of a facility, the ADA Chapter 7 Toolkit is a great resource for that. While we covered that quickly, this provides a level of insight on what application of this process might look like. And so at this point, we have concluded our formal presentation, and I believe I'm passing it back to Brian for questions.
Well, thank you very much, Kyle and Linda. That was fantastic. I really appreciate that overview, and we've got a number of questions. Thanks to everybody who put those in there. So I'm going to run through these questions here on my screen. If you have questions, probably the best thing to do at this point is to just type them into the question box on the right-hand side, and I'll see them pop up on the screen. The first 2 were a couple of technical issues. and we'll put those. I'll address those in a minute. Debbie Jackson had a number of questions. I'm going to start with Debbie's first question. Says population of people with accessible and functional needs includes people with disabilities, but also goes beyond people with disabilities. What other groups of people does access and functional needs include? So I'll throw that out for both of you.
Linda, would you?
Sure. So access and functional needs, you're absolutely right, does include more than just disability, although I was focusing very much on the disability population today, but it deals with older individuals, it deals with non-English speaking, it deals with children, so it's a much broader base of people than the estimated 60 million people with disabilities across the United States. It's a much broader population. Kyle, did you have anything you'd like to add?
I would just say one of the questions that we get often is just how to approximate that number to just get some sort of baseline for planning purposes. And while the census data provides a starting place, it's really not that comprehensive picture. So we've relied on a number of best practice planning standards as a starting point, but really it does come down to a community by community understanding of the demographics, the needs, and sometimes that requires a really detailed assessment. As we mentioned throughout the presentation, one way to get a big step forward in that is to access existing resources in the community that are already working within those populations. And so rather than starting from zero, you're building off of the work that they do on a day-to-day basis serving those populations.
Okay, good. Thanks, guys. I'm going to combine two questions and then add a little bit of my own for this next one. The two questions first is from Gail Robinson. It said, if a client was paying for a PAS prior to the disaster, does compliance include helping them find a PAS to provide the service in the shelter, or does the shelter have to pay for the PAS for the client in the shelter? The other one is from Debbie Jackson, who said, when working with interpreters and DRS providers, do you ask for volunteers? How are interpreters paid for and who pays? And then finally, my question is, in the slide we say that we're responsible for providing access for durable medical equipment, for consumable medical equipment, and for personal assistance services. So does access always mean or sometimes mean providing at cost or at no cost? So all three of those are cost and money questions. Who is the government? Are emergency management responsible for providing all of those at no cost, or are there other models that work in that situation?
Linda, would you like to get started?
Sure. So let's start with the personal assistance service or PAS question first. If a client is paying for PAS, and let's say for some reason they are able to evacuate with their PA and that person is sheltered with them, then the expectation would likely be that that individual would continue to pay their PA for services. Let's presume, on the other hand, that they get separated and the PA is not at their home when they get evacuated. That individual is going to need PA services, and that PA can't get to the shelter. Let's say they're, who knows why, for whatever reason. Then it would be the expectation that the shelter provider would pay for those PA services at their cost. And if you might remember that I talked about not imposing surcharges on individuals with disabilities to benefit from programs and services. So this is one of those areas where that applies. Similarly, with interpreters, if you have an individual who is deaf or hearing impaired, or for that matter, someone who is non-English speaking and needs an interpreter, it would be the expectation that the shelter or the emergency management program that this individual was attempting to access would pay for the cost of that interpreter. It would not be borne by the individual. And again, it's because, in part, because you can't impose surcharges for the cost of accommodation on the individual with disabilities. And then going on to the access to durable medical, consumable medical, etc., obviously it would be the preference of emergency managers, and I'm sure the individuals who are taking medication, let's deal with that issue first, and using consumable medical, that they would show up at a shelter with the stuff that they need, right? But sometimes we know that just doesn't happen. And so really, it's going to be a little bit of a two-part answer here, because that individual may have access to insurance, which is going to cover, ordering another dose, but maybe they don't have access to their information because their house went floating down the river and they don't have their insurance card. So, there may be some expectation that some of this is going to be provided by the shelter in the beginning, again, at no cost to that individual. Durable medical is a different question. It can be quite costly, of course. If an individual uses a wheelchair, it could be $3,000, $4,000 for a power wheelchair. It could be $20,000 or $30,000, so quite expensive. And most emergency managers probably aren't going to have that kind of money in their budget. So the thing to think about here, for example, is if someone's going to be evacuated, the first preference is to evacuate them with their durable medical so that they have the exact equipment they need at the shelter or wherever they happen to, if it's post-disaster housing or the shelter or wherever they are. But failing that, let's say that their chair is destroyed in a fire or a flood and they're evacuated without their equipment, there is no expectation that the emergency manager is going to buy them an exact replica of what they lost. They will do that with their own insurance provider, but you will need to provide them something to give them access while they're at the shelter or participating in your emergency management program. Does that help answer the questions, or can I elaborate on anything?
Hey, Linda, thanks for that. And I think in the interest of time, I'd like to do a couple more questions before I have to turn this off. The next ones are regarding pets. We had 3 questions from Laura Levine, Debbie Jackson, and Helen Miller. Okay. What determines a service animal? And then the second one is they refer to them either as comfort pets and emotional support animals. And does the law cover this at all? And if so, how do we deal with that situation?
Okay. So the important thing to remember here is that under the Americans with Disabilities Act, they recognize 2 classes of animal as a service animal, a dog or a miniature horse. The Americans with Disabilities Act doesn't recognize any other animal, and they actually don't have any provisions for emotional support or therapy dogs or animals in the law. That being said, this doesn't mean that, for example, the Fair Housing Act defines service animal differently. So do many state and local regulations. And when you think about it, my best suggestion is to think about what is happening with people when they're coming to your shelter or your program. They're under a great deal of stress, a great deal of trauma, a great deal of despair, and my best recommendation is that you think about how best to enable that individual to benefit from the programs and services of the shelter, which very likely will include keeping that animal with them, whether it's legally defined under the Americans with Disabilities Act or not. You want to err on the side of giving them access versus denying them access. It can be difficult and challenging, I understand that. But the preference is to presume access. And the important thing about that also to remember is that you can't ask for licensure of an animal. There's no such thing. There's no certification. There's no licensure. You can ask someone, what functions is this animal trained to perform? And then if someone gives you an answer, then you take that on faith that that's the answer.
Linda, if I could just add one thing here.
Sure.
The definition of service animal has probably been the one area there's been the most variance on the state-by-state or jurisdiction-by-jurisdiction level. And so I'd really encourage participants who have this question to look at those local requirements.
Yeah, that's a great point, Kyle.
All right, thanks, you guys. I've got one more short one.
Sure.
And then we'll wrap it up. And for everybody else, we'll address these separately, either via email or perhaps post them all to the website, which is, how are dialysis services addressed at a shelter? Are you expected to provide that, or can you move those folks to another facility?
So ideally, again, services are going to be provided in an integrated manner in the general population shelter. However, An option would be, for example, to provide accessible transportation or transportation to a dialysis facility to enable that individual to receive their dialysis and then return to the shelter. Kyle, did you have anything you'd like to add to that?
I would just reiterate that point. I think that that's right on, is that oftentimes that capability doesn't exist within a mass care environment, and so the accommodation is made to have regular transportation provided to another community resource. A great example of integrating the community into your mass care planning.
All right, Linda, Kyle, I'm back on screen now, guys. Thank you very much for being with us today. I'm not sure how you do applause over a webinar, but everybody out on the web, if you would just please clap in your office for them, I appreciate it. Again, thank you guys for taking the time to be with us today. For everybody on the call, on the webinar, thanks for being here. We're going to declare this a success. We had over 125 people. I think we hit a high of 130 something on this. We're going to do a couple more webinars this year, and we'll put out information on the topics and dates on that soon. A number of you had questions about how are you going to access these slides. We will post, and Karen will disabuse me of this notion if I'm wrong, but we'll post the slides and the webinar to the website as soon as we can. We'll also address all the questions that were not answered today, and we'll push that information out to you as soon as we can for everybody. So again, thanks everybody for taking an hour with us today. Linda, Kyle, thank you for being part of this. Karen, thanks for setting this all up, and I look forward to talking to you all again on the next webinar. Bye.